and have a cup of coffee and breakfast while listening.
Cool. I just thought I'd say hello firstly, and then I just,
Thank you.
if everyone is there and up and running, just do a quick introduction and good morning to everyone. Tiff, can I get going?
Please.
Yes, I see we've got 32 people online, so please go ahead.
Thank you, Tiff. Thank you, Terence. Good morning, everyone. This is Vaughan Hutton. I am part of the CAASA Exco, and together with Reg and Michelle and Norman, we put together these training workshops, and we've presented several over this year, all I might say quite successfully. So thank you all very much for your participation today. Today we've got Terence Ossin, who is counsel at Group 1. Sorry, Terence, I almost gave that away. I thought you were at Group 1 still, but that was a while ago. Terence is a practitioner at the Joburg Bar, and he is also well versed with construction contracts, and in particular the NEC. And Terence is going to be tackling, I think, probably one of the most fundamental things about adjudication and with adjudication, and that is the drafting of papers, the drafting of referral, and he's going to be looking at techniques in drafting. And it's fundamentally important to appreciate what has to happen and what goes into the adjudication referrals, given that the adjudication process is largely run on documentation without the benefit of oral evidence, without the benefit of cross-examination and the like. So the referrals and the documentation and the exchanges that have to happen through the adjudication process are critical to the success or otherwise of that process. So Terence, as I say, is a seasoned campaigner. Thank you very much, Terence, for doing this presentation today. And everybody, thank you for joining in, and I hope you enjoy the next couple of hours. And please feel free to ask questions afterwards or post questions to either Terence, myself, through Tiffany or anyone else, including Reg. And have a good couple of hours. Thank you very much. Terence, over to you.
All right, great.
Thank you.
Thank you, Vaughan. And I just want to say thank you to CAASA. Thank you, Tiffany, for organizing this lecture as well. In terms of the content of the lecture, I want to thank Michelle Kerr. She provided me with some with a basic outline for some of the content. And I also had regard, and we'll make mention at the end, to some online articles that you can find in regard to practicalities relating to the submission documents and what you have to look out for. What I propose doing is I have essentially two documents that I will be putting on screen during the course of the lecture. The one document is a content document setting out a summary of what we're going to be dealing with today, and the other is a table which compares the various four pro forma contracts plus the CIDB rules as well as CAASA's rules. And in regard to that table, I'm concentrating on the various time periods and what documents the contracts allow you or provide for submission in the context of the adjudication itself and the ramifications and consequences for getting and obtaining an adjudicator's decision in the quickest possible time, and a decision that will read effectively. Because certainly in the context of court matters and arbitrations, and I would suggest also in the context of adjudications, the quality of the adjudicator's decision would be informed by the quality of the documentation that is submitted to the adjudicator by the parties. I'm not saying that is the be all and end all of the quality of the adjudication decision. Adjudicator should be able to put forward quality decisions, but certainly the adjudicator's job will be assisted immensely and might be hampered by documentation that is not easily understandable, easily digestible. And as a precursor for that, so let me now just share screen, and sorry, I might not be as technically advanced as some people here. Share screen. There we go. Perhaps before we start, before I get into the nuts and bolts of this, it's always good to know from participants as to the level of exposure in regard to adjudications in general and in drafting submission documents. It just helps to pitch the lecture. So if anyone wants to, I'll assume if no one puts their hand up, that everyone has had some exposure to adjudications and to drafting or to drafting submissions. So a hands up or will say that the person hasn't. Don't be scared to put your hand up. What I want to do is, and I'm just going to jump ahead, and I'm sorry, this is still on a PDF format. We're still going to get it into, thank you, Mervyn. I want to jump to a case. You'll see it here, future developments. It's a case out of Australia. I actually found this while searching the internet. And what was very interesting about this, and it's not so much the outcome of the case and the details regarding the claim that was put forward. It was an asbestos claim. There was asbestos found on a road and drainage works project, and the contractor put forward various claims. What the court actually said was that the respondent's response, so the respondent had responded to the claim in the adjudication, was lengthy, rambling, difficult to follow, complicated, and confusing. And as you would all know, because adjudication is supposed to happen quickly, and more often than not, and I'm a proponent of adjudications not going to oral hearings, but we can get to that. The fact that a submission document, whether it's the submission by the claimant or the response by the respondent, if those documents are confusing, it's going to take a lot of time for the adjudicator to try and unpack that. And because the adjudicator is taking time to unpack that, the adjudicator has less time to actually spend on the merits of the matter. And that's why I'm talking about the necessity for the documentation to be easily digestible. We'll get back to that decision, but one must bear in mind that that when one is drafting the documents, and this is whatever documents you might be drafting, keep them simple, make them easily understandable, use short sentences. Don't try and put a whole lot of different ideas into one sentence. Rather put a full stop. I know this might be trite for many people, but it does make reading the document easier, and it does make the document more understandable. All right, so with that in mind, the first stage, I suppose, is what documents does the contract allow you to submit to the adjudicator? And the starting point for any claim is of course the contract. Know your contract. So that's the first point. The second point is the contract itself what kind of discretion does it give the adjudicator to regulate the procedure, and specifically the documents which may be submitted? Some pro forma contracts, like the JBCC, contractually allow a submission document or statement of claim, a response document, and then what is called a replication, which is a short response to the respondent's response to the claimant's submissions. The other contracts, as we will see, don't specifically provide for three documents to be exchanged, and to some extent that would then be left up to the adjudicator. We'll get into that when we look at the table that you'll see that I've referred to in that fourth bullet. This is important as well, i.e., what documents may be exchanged, because it may to some extent inform the content of the claimant's submission or referral document. I say may because I'm a proponent of the claimant, when the claimant puts forward its case to the adjudicator in writing, the claimant ought to also deal with must deal with the nature of the dispute that has arisen, and ought to deal with and ought to answer the contentions that have been put forward by the other side. So, for example, the contractor is putting forward a claim or a submission to the adjudicator, and by that stage, there's been notice of disputes and possibly notice of adjudications, and the claimant would know what the employer's position is in regard to its claim. So one ought to then deal with that upfront in one's referral document, and not wait for the possibility for the defense to come in via the respondent's submission document, and then hope that one can now get in an answer to that in a third document. I think that's dangerous, and it also, and bearing in mind the timeframes involved, it might not be practical. I will run through quickly this table that I've prepared. All right, and I will try and. What I want to try and just get it bigger there. All right. We've got essentially the four pro forma contracts of JBCC, GCC, FIDIC, and NEC. I've added in the CRDB adjudication procedure, and I've added in CAASA's rules. What I want to show you in this first block here is the number of days that the various contracts allow for submission. So I've calculated this for JBCC from the date of the submission document to determination date. It's 35 working days, which is plus minus 48 calendar days. Right. Note that the written determination from the adjudicator has to be given within 10 working days after the last document has been submitted to him or her. Right, so that's very little time. If the documents aren't easily understandable, there's going to be a problem. GCC essentially is 56 calendar days from submission. The CRDB is 28 calendar days. The CAASA's dates are 42 calendar days from submission. The decision is 21 days after submission of the last document. CRDB is 28 days, as is the GCC. FIDIC is 84 calendar days. So on the face of it, there's a fairly lengthy time period there, but it's quite a fluid procedure that the adjudicator is entitled to put in place there. It's not that prescriptive. And the NEC also essentially is 12 weeks. So it also works out to 84 calendar days. There's no difference really in that respect between NEC 3 and NEC 4. And no real difference between the FIDIC 99 and 2017 edition. What you'll also see is that the JBCC is probably the most prescriptive or contractually prescriptive contract of all of them, because it actually prescribes a submission document, then a response document. It prescribes a replication, that is a response to this response document, and then prescribes a written determination. The other contracts don't specifically prescribe a replication document, and in fact, in some of them, I don't believe that a replication is even would even be allowed. Then, of course, you've got the conduct of proceedings and the discretion of the adjudicator, and I would urge you all to look at your contracts, to look at the rules that are involved. The JBCC, you'd look at the clauses, the clause 30.6 together with rules 3.6, and you'll note across the board between these various contracts that for the most part the adjudicator has discretion how to conduct the adjudication within the confines of the contract and the rules. The adjudicator is entitled to set out a procedure and a timetable, but please note that that's within the confines of and subject to contractual limitations. So the argument would be if the contract doesn't provide for a replication, for example, is the adjudicator in fact entitled to require or to give the claimant the opportunity to put in a replication. I'm not going to go into whether adjudicator is or is not. Each matter will really depend on its own facts. And it's quite possible that in many of these contracts, a third document will be allowed. But again, that document will be very limited in scope. So adjudicators really across the board have generally wide discretion. We talk about the observance of the rules of evidence. So in court, you have rules of evidence. Those are not strictly observable in the context of an adjudication. So evidence which might otherwise not be accepted in court could well be accepted by the adjudicator. In regard, I want to just highlight this in CAASA's rules, Rule 3.3. There's an interesting. The adjudicator has been given an express power to limit the length of the written documents. That I haven't seen that express power being stipulated in any of the South African contracts that we're talking about here, and I'm not aware of it in the context of FIDIC or NEC. Not to say that the adjudicator, in general terms, would not have the power to limit the length of written documents if the adjudicator is entitled to establish procedure and et cetera. But what is interesting here is that it's expressly provided for, and I can understand why, because if one gets into very lengthy documentation, then there is a possibility that the documents might become unwieldy. And of course, the adjudicator has to come to a decision fairly quickly. The adjudicator doesn't have the benefit of oral evidence generally, and the adjudicator has much more limited time than an arbitrator would have in giving his or her decision. Limiting the length of written documents I would say is not against the rules of what we call natural justice. Indeed, in court scenarios, there are some procedures where there are express limitations as to how long a document can be. So that's. But I would say to you that if you are going to be putting in documentation, try and keep it as simple and as short as possible. These rows here dealing with the dispute notice and the adjudication notice. The reason why I've put them in here, and again, is because they do start to set out and to provide you with some guidance as to what your ultimate, if you're the claimant, your ultimate submission should contain at the very least. And what we have, for example, is the dispute notice under the GCC. It says that your notice must clearly state the nature of this dispute and the extent of the redress. In other words, what exactly are you seeking from the adjudicator? Notice of adjudications. So, for example, the JBCC says, you must clearly define the scope of the dispute in your adjudication notice. You must set out what relief you're seeking. And the rule then extends that by saying, set out the nature of the dispute, the brief description of the dispute, the details where and when the dispute arose, the nature of the redress sought, and quite fundamentally, the name and addresses of the parties involved. GCC has a similarly, it then says, we'll set out the details of the contract. The CRDB here says, set out the details and date of the contract, set out what the issues are that the adjudicator must decide. So you can see here that already in your dispute notice and your adjudication notices of the various contracts, you're already being given guidance as to some of the fundamentals that ought to then be contained in the submission document. Right. Then we get to the actual document, the actual referral. Call it a statement of claim. I don't necessarily like that term because it does bring to mind arbitrations, and there is generally somewhat of a difference between what a statement of claim looks like and what your referral document or your submission document would look like. JBCC tells you what your referral document must contain. It must contain full details of the dispute. It must contain the notice of adjudication, and then it tells you what the details of the dispute comprise. Okay, so what they call the statement of claim, which is essentially would be your actual written document, the copy of the contract, description of circumstances giving rise to the dispute, supporting documentation, grounds on which the party seeks redress, evidence relied on, and relief sought. So if you go through these contracts here, you'll see similarly they set out to some extent, with the JBCC, I would argue, setting out being the most prescriptive in terms of what has to go into the referral document. And so they actually act as some sort of guidance or guideline for you to tell you what should go into your referral document, no matter which contract you find yourself in. In fact, when you start getting to the FIDIC and the NEC, you'll see there that there's no prescription as to what your submission document, at least contractually, must contain. Right? It doesn't offer any guidance. It says you put in your submission document. The NEC says party referring dispute to the adjudicator includes with the referral information to be considered by the adjudicator. Okay, so what information is that? All right. So we'll go into that in a bit more detail. But for the moment, you can already see the pattern in terms of at least the JBCC gives some guidance as to the minimum that should go into the referral document. You've got the responding document. There, in most instances, you submit the respondent, the employer would submit their written response. And what is important with the responding document, and the JBCC actually stipulates this, is that where there is a submission or a fact put forward by the claimant in its referral document, and that is not dealt with by the employer, by the respondent in the responding document, that failure, the person will then be taken to have admitted that claim, or admitted that contention. All right. The only contract that expressly deals with the replication that I can see is the JBCC. What the JBCC says is that in answer to the, let's say, the employer's response, no need to, you can put in a replication dealing with specific new matter that has been raised in the response, but you can't put in any new argument that you haven't contained in the details of the dispute. There are general rules across the board which say that the parties are to be given reasonable opportunity of putting their case and responding to the other's case. That's certainly in the case of FIDIC, and that's obviously in line with the rules of natural justice. But I would urge you not to expect, when you are drafting your referral document, that you will be given a second bite of the cherry. I would urge you to be as comprehensive as possible in your referral document, and to deal with whatever disputes and whatever contentions you are aware of that exist at that time, and deal with them up front, because if you don't, you may not have an opportunity to then answer them later on, and your failure to do so could be viewed and inferred as an inability on your part to deal with it at the level of submission, not at the level of competence, but because you just simply don't have a decent answer. Of course, during the adjudication, and in most of these contracts, the adjudicator can ask for further information or document or evidence, but again, I would urge you not to rely on that, and take it that the only thing that the adjudicator will have before him or her is your referral document, and if you are the respondent, your responding document. Right. Let's share this. Right. I'm not sure whether my new screen is up. Tiffany, is my new screen up?
Terence,
The written screen, not the table.
Yeah, the normal document.
Yeah, the written document.
Yes, it's there.
That's up. Okay, great.
Yeah.
Fantastic. Thank you very much. All right. There is a lot to get through, but this is a practical lecture. So if you do have any questions that have a bearing on a section that we've maybe just finished, then maybe we could deal with that, and then move on to the next section. Well, what we've just done is I've just given you an outline of the various contracts, and the kind of the contentions that the contract stipulate for. So that's just a very broad outline. If anyone has any specific question related to that, please feel free to ask, or you could put a message or something, and we can deal with that. Onus of proof and evidence. Now, us lawyers talk about the onus of proof and discharging the onus of proof, which means meeting your onus. making your case and proving your case. We talk about a standard of a balance of probabilities. So the adjudicator will then have before him or her the claimant's referral document and the response, and based on the quality of the evidence and the facts put forward in those documents, the adjudicator will then have to come up with a decision. And we talk about that decision, the balance being the balance of probabilities, i.e., is it more probable that the contractor's case, as set out in the claimant, exists as opposed to the employer's case. So the claimant, essentially, he who asserts must prove. So the claimant must now go ahead and prove his or her case, or its case, and the claimant bears that onus. The onus, this is what we call the onus of proof, the overall onus. It doesn't shift to the respondent at any stage. So at the end of the day, if by looking at all the documentation before him or her, the adjudicator decides that the claimant has discharged his or her onus, then the adjudicator ought to then find for the claimant. What is important, however, for purposes of the submission document, and I wouldn't harp too much on this onus of proof because it's quite a technical issue, is the evidence. What evidence are you actually going to be putting forward to the adjudicator? Someone, a retired judge, once said to me, "Don't worry about the law. The law is the law. The law will sort itself out. Worry about the facts. Worry about the evidence. Concentrate on that." Most matters will hinge on the evidence, and not only that, they'll hinge on the quality of the evidence that you put forward. So, as the claimant will bear what we call the evidentiary burden, at least initially. So the claimant will make certain assertions of fact, but those assertions of fact ought to then be supported by some form of evidence. And what one is seeking to do is to produce the best evidence that is available, whatever that evidence might be. We'll deal with what kind of evidence is available. If the claimant now puts forward their case, their referral document, and attaches a whole lot of documentation as evidence in support of particular facts, depending on what that on that evidence and the quality of the evidence, the evidentiary burden would then shift to the respondent, to the employer, in its response to now try and gainsay or oppose the evidence that has been put up, and in doing so, the respondent will look at ought to look at the quality of the evidence that has been put up by the claimants and try and better that. So that shifting of the evidentiary burden will to a large extent depend on the quality of the evidence produced at each stage of the proceedings. Are there any questions there? All right. Evidence. When we talk about evidence, what are we talking about? Well, in the context of the adjudication, and I wouldn't harp too much on the first one, which is real evidence such as objects. We're talking here about documentary evidence and oral evidence, oral statements. So documentary is daily diaries, for example, drawings, variation notices, etc. Certificates. Could also be correspondence between the parties. Oral evidence is evidence from persons involved on the project and persons involved in particular with this particular dispute, and depending on what the issue is, one might have to resort to oral evidence. And when I say oral evidence, it would then be in the form of what we would call witness statements, or some statement that you would then, as part of your submission document, put forward to the adjudicator. So those are the general categories. Types of evidence, in other words, the quality of your evidence. So you have direct evidence, which is, we say, a direct assertion. You have circumstantial evidence, which is really indirect or inferences that we want to draw from the particular evidence. You've got primary evidence, secondary evidence. Primary evidence is there's no better evidence available. Secondary evidence is that there is better evidence available, but this is the best that we've got at the moment. And then you've got hearsay evidence, which is where you've heard from someone that a state of facts that affect something happened. Now, in the context of court matters, hearsay evidence is generally inadmissible. There are exceptions, but because we're dealing here with an adjudication, you might be able to get hearsay evidence in more readily than otherwise. However, I wouldn't want to rely on that. You always want to go back to the direct documentation, to the actual notices, to the actual, if necessary, an expert report, a common cause fact, and you would then want to put that in as part of your submissions. Always, when you are putting in evidence before the adjudicator, ask yourself: is there anything better than what I'm putting in? So, am I putting in evidence which really raises an inference, or am I putting in evidence that directly supports the fact in question? Because at the end of the day, one of the things that the adjudicator will be doing is to look at the type of evidence produced by each party, and then assessing the probabilities based on that evidence. Okay. Any questions there? The type of evidence we're talking about will become a little bit clearer later when we go into the actual content of the submission and the responses. All right, general guidelines in respect of your submissions and responses. The first few here really are probably more appropriate to the submission document. Remember, the task here is to make it as easy as possible for the adjudicator. So your written document probably should have a table of contents. So it gives an outline. You should use headings. The documentation that you're attaching, your annexures, perhaps you would want to include a table of annexures. Obviously, everything will be paginated, i.e. every single document, you'll start with page 1 and you'll paginate it all the way through to page 30 for your submission document, and then you continue the pagination for your annexures. So that will be page 31, page 32. So it's easily cross-referenced and viewed. When you're making your submissions, you'll obviously want to put in paragraph numbers. So don't just put in your submission as if it's a book. You'll start with paragraph 1, and you may want to have some sub-paragraphs if what you're talking about is one issue. Make sure that your font size is not less than 11.5, and make sure that the font is legible. I've got smiley faces there because that font size should have been 11.5, should have been like 6, and you shouldn't have been able to read it. Go with Arial. It's the safest. Don't go with squigglies. Your spacing probably should be double spaced, but 1.5 is probably enough. And when you are referring to documentation in your actual written submission, then give it an annexure number, designate it with an annexure number. So you can either, so your first document will be document 1, but what you might want to do is put the initials or some sort of initials of the claimant's name, and designate that as S1 for submission, or R1 for response, or whatever it is, so that it's easily identifiable. What also is a good idea, and what I found very helpful, is that when you are referring to a document that is attached, in the actual submission document, your written document, you will then put that annexure number in bold, and you might even put a red color font, maybe red bold, so that it jumps out and one is and one can identify that very quickly. Why am I harping on this? Again, we know that adjudication should be quick. That's the point of it. Some adjudications nowadays are becoming like arbitrations, and that really is not the intent, and certainly doesn't help the parties, or at least the poor contractor who now has a cash flow problem. Having said that, though, the adjudication obviously can have very far-reaching ramifications, especially for the losing party. And it could make or break a subsequent arbitration depending on the outcome of the adjudication. So essentially, the process has to be respected. The adjudicator's position ought to be respected. And by what I mean there is that respect the adjudicator by putting in a document that the adjudicator can readily and easily digest, and obviously respect your submission documents. I am a substance over form person, but I do believe that if your document looks good, and on the page it actually is easily readable, that helps a lot. I'm not saying that if you put in a nice looking document you're going to win, but putting in a horrible looking document, a document that has very tight spacing and no headings and what have you, it is going to irritate the adjudicator, and might somehow put the adjudicator off course a bit. When you are making your submissions or you're putting in your responses, think about it from the adjudicator's point of view. Your submissions ought to be adjudicator-centered. So whatever you're putting into your document, one should ask oneself, how is this going to, how does this aid my case? And two, am I putting it in a way that will assist the adjudicator? The adjudicator doesn't know the case as well as you do. You must advocate your case, and you do that through your submission document and persuasive documentation. Don't be afraid of spoon feeding the adjudicator. Make the adjudicator's job as easy as possible, and make the adjudicator want to actually read your document. Of course, the adjudicator is being paid to read your document and to give a decision, but we are humans, and we want to enjoy what we're doing. We've dealt here with the claim and the response to be properly evidenced. So whatever facts you put forward, make sure that you have some sort of evidence to back it up, some sort of documentation, or if there is no documentation, an oral statement by someone directly involved. As I've said before, assume that the adjudicator's decision and jurisdiction is limited to what you have set out in your documents. Don't rely on the adjudicator interrogating other issues not canvassed, even if the adjudicator has the power to do so. But a good document, whether it's a referral or response, is contingent on your preparation and your groundwork, even before your adjudication formally commences. This can be done, or probably should be done, at the time when the notice of dispute or notice of adjudication is issued. It's at that point in time that both parties ought to be collecting the evidence that they would be looking to put forward. And while they may not be formally preparing the referral or the response document at that stage, at least this groundwork can be done at that stage, especially when it's fresh in people's minds. And perhaps even you can start getting statements from the persons who are directly involved, even at that stage. Avoid badly prepared submissions due to haste. Yes, we are dealing with a quick process, and it should be a quick and efficient process. But don't put out a bad submission because you are hurrying and because you found that, well, we've lost a bit of time because we didn't obtain documentation or statements that we could have obtained at this early stage of when the notice of dispute was issued. Of course, also you need to make sure, and depending on who's putting in the referral document, make sure you have enough resources to actually deal with the adjudication documents. Who actually is going to be drafting the documents? Who are the who are the people who are going to be involved in collating it? Remember, from a particular point in time, that submission document is going to have to go in, depending on your contract, 10 days, 15 days, 4 weeks with the NEC. Do you actually have people to actually deal with that and put together a document that's going to read well? So you need to plan ahead. I'd assume that contractors would know how to do this. They would be planning the project. So in the same way that you plan your project, plan your adjudication process. One thing that it is important to note this, and that is that the claimant probably has more time to put in its submission document than the respondent has to respond, which doesn't sound fair, but that's just the way it is. So in terms of planning, the respondent should actually start at an earlier stage even than the claimant, because by the time the submission goes in, the respondent will say have 10 days to get their response in, or in the NEC it's 4 weeks. But whatever it is, if that groundwork has been done and the documentation has been collected, putting in the formal response will be much more, will be quicker, it will be more streamlined, and you'd be able to deal substantively with whatever new contentions are put up by the claimant, which you may not have foreseen before. But then at least you're not spending time dealing with issues that you ought to have foreseen before, and you've got those answers at your fingertips. So start getting the facts and supporting documents together at an early stage. Certainly in the case of the claimant, your case must be logically set out. Tell your story. Make it look nice. Start at the beginning and end with your conclusion, and fill in the logical steps in between. We'll get into the details of what exactly that means. As I've said, the quality of the documents will impact to some extent on the quality of the adjudicator's decision, remembering, of course, the limited time period, and that easily digestible and logical documents mean that the adjudicator has more time to consider the merits and not have to waste time trying to decipher exactly what you are saying. Keep your sentences short. All right, here's the future developments. Here's the future developments case. Now, what was interesting, we've already looked at what the response, what the court said the response was. It was a lengthy, rambling, difficult to follow document. What is important here is the following. So the adjudicator had upheld some of the contractor's claims, and the employer then wanted to sought to review them in court. What the employer had said was that the determination was void because there were jurisdictional errors, that the adjudicator had failed to have proper regard to the employer's submissions, or failed to provide adequate reason reasons for his finding, and therefore denied the employer, the plaintiff, procedural fairness. What was important here was the adjudicator had only 10 days to make his decision from the time of the submission of the last document. And what the court then said as follows: in my opinion, these reasons adequately address the issues raised by future power, that's the employer. It's plain from the summary that the adjudicator had carefully considered future power's submissions. Moreover, it is relevant in considering the question whether the adjudicator gave adequate reasons for his decision that he was required to deal with lengthy, rambling, and difficult to follow submissions in a short period of time. So the courts will look at that and say, well, what was the quality of the documentation given to the adjudicator, and could the adjudicator have then been expected to have considered all of those submissions because of the way in which those submissions were put up? So that is important, and one must bear in mind whether you're the claimant or the respondent. If it doesn't assist the adjudicator, leave it out. If it doesn't assist your case, leave it out. Don't irritate the adjudicator. Succinct, relevant submissions. Avoid repeating arguments. Avoid repeating arguments and facts. Avoid snide and sarcastic, emotionally charged remarks. It doesn't help. One sees it in court affidavits. Malicious, malafides, disingenuous. It doesn't take the matter any further. The adjudicator is not impressed by that. You're wasting time, and it doesn't help the case. Keep it clinical. When you're referring to documentation, it also might not be a bad idea. We spoke about your annexures and putting your annexure number in bold and what have you. You might even, once you've paginated your submission document, so you've got your referral document, 30 pages, plus your documentation, so that's another 50 pages, there's 80 pages. You go back to your referral document where you've got an annexure there, you then put in another color the actual page where that annexure can be found, so that the adjudicator reads it, looks at says this is the annexure, and immediately is told which page the adjudicator can find that annexure. All right. Any questions? Let's just see. Okay, I see there's a question from Gordon. Gordon, can we get to that at the end? It's an interesting question. It's regarding strategy or recommendation in working with a hostile respondent. All right, can we get to that at the end? It's a general question, and it's a good one. Thanks. All right, general guidelines for drafting referral documentation. Again, draft it carefully. It may be your only opportunity to make submissions to the adjudicator. It will have two parts, as we've said: your actual referral document and your supporting documentation. You ought to put all relevant matters into it, including dealing directly with the dispute and the contentions raised by the other side. Know what your case is before you start drafting. The existence of a dispute, as you would all know, is at the essence of an adjudication or an arbitration. If there's no dispute, there's no adjudication. So it's essential to your case that you actually place before the adjudicator and show the adjudicator that there is a dispute, and that the dispute has crystallized through the various contractual mechanisms, and you must show that the various contractual hoops have been jumped through to allow you to actually be in front of the adjudicator. As we saw from the table, if the contract or the rules require specific information, then make sure that that is included. Of course, you ought to be including that anyway. Whatever you contract you are using, but I caution that if the contract or the rules in question require specific specific fact or information to be put into your referral document and you don't do that, then it could be argued that you have not complied with the rule, or if you're not complied with the contract. And while it would be a robust adjudicator who does so, there is a possibility that your claim could be rejected, or the other side might take the point and make your life more difficult. So don't get to that point. Rather, follow the letter of the contract and the rules, and then obviously make sure that you make out your case. All right, so you must make out your case, what we call your cause of action. All elements of your cause of action must be concluded. I'm not going to be prescriptive as to what that might be. It really depends on the nature of your dispute, but I would at the very least be talking about these points here. You would want to set out who the parties are, so that the adjudicator knows. You would want to set out the details of the contract, when it was concluded, where it was concluded. You would attach the contract. You would refer to the relevant contractual terms. Although you attach the contract, not all the terms in the contract are necessarily relevant to your matter. So highlight in your submission document itself which you believe are the relevant or material terms that the adjudicator ought to specifically have regard to. You would probably want to say what the nature of the project is, and then you would want to put into your document the relevant facts in chronological order leading up to, for example, the breach or the variation that occurred. You would then want to probably say what work was done in respect of the variation, possibly if it's contractually appropriate, and after that you would put in the details of the claim, when you notified the claim, the details of the claim. Obviously the claim documentation would be attached. You would then put in the rejection of the claim, including details as to why it was rejected. You must include the notification, the dispute notification, setting out the details of the dispute. You would want to deal with the factual and legal basis why you say the claim was wrongly rejected. So that's from that side, and then you would want to say why your claim should have been upheld, maybe by the project manager or the principal agent, and why the adjudicator ought to uphold your claim. As I've said, include opposing contentions and address why you say they are wrong. You may at the beginning, so those were the general matters in regard to your cause of action. You may at the beginning want to, as a general guide for the adjudicator, put in broad submissions, using the headings as a guide, so setting out in a couple of paragraphs, this is what this is about. It relates to this an NEC3. It relates to variations. There's a claim, a compensation event. There's a dispute. There was a rejection by the PM. There's a dispute. This is what the PM says. We say the PM's wrong. This is why we say the PM's wrong, and we're seeking the following relief. So it's really just sort of a broad summary at the beginning, if appropriate. What is very important is that you must state what relief you seek. You must be very specific in regard to that, because if you don't state if you're not very clinical as to what relief you seek, it could be that the adjudicator would not give you anything other than that, and the relief that you seek might not actually be helpful to you. So it's one thing to ask for a determination that the claim should have been assessed at whatever amount, but then have you asked for actual payment of that in your relief? So don't forget to leave that out. The other thing is that ask yourself why did the PM or the PA reject your claim? Maybe the documentation that you put forward at that point in time wasn't sufficient, and maybe that's why it was rejected. So if you then go and put forward the same documentation now in front of the adjudicator, you might land up in the same position. So don't be scared of broadening your scope of the kind of documentation and evidence that might be necessary to prove your case in front of the adjudicator. If you want to refer to extracts from case law or textbooks, you ought to do so. Obviously, you should attach them, and we obviously your various notice, certificates, correspondence, relevant correspondence should be attached and marked as an annexure. When you're doing that, and certainly in the context of court matters, people could attach a document that's 15 pages long and say, well, here's the document and it supports my case. But now the poor adjudicator has to now go and wade through this document to see how does it support your case. And it could be that only half a page of that document is relevant. I'm not saying you must attach only that one page. Attach the whole document, but then tell the adjudicator which portions of that document are relevant, and say why. You can't expect the adjudicator to look for your case. As I've said, you've got to spoon feed the adjudicator. All right. So we saw earlier what our various causes of action were, and your headings might be informed by the cause of action, by the cause of action and the elements. So again, I'm not here to be prescriptive as to what your headings should look like, how they should be formulated. These are just these are general guidelines. So you may start with a summary of the claim or the parties. As a heading, you would have a heading, applicable contracts and relevant terms. You may have a heading, nature of the dispute and the basis why the adjudicator has jurisdiction, why it's become a crystallized dispute in front of the adjudicator. You would then have a heading, facts giving rise to the claim, or background facts or surrounding facts or something along those lines. A heading, submission of the claim, notices, etc. You would then deal with the response from the employer or from the PM, and under that you'll deal with your certificates, etc. Your contentions as to why the response you say is wrong. A heading that deals with your case and why the adjudicator ought to find for you, and then of course the relief or the decision that you want the adjudicator to make for you. You need to make sure that the relief makes sense. As I've said, if you ask for an assessment in a specific amount, you also ought to ask for payment based on that assessment. But what you might also want to do is when you're asking for an assessment in a specific amount, you might want to broaden that and say, or whatever other amount determined by the adjudicator, so that it gives the adjudicator that broader power to actually give you, if the adjudicator isn't with you in regard to the specific amount, the adjudicator might be with you in regard to something slightly less than that, but more than what the PM had given you, etc. All right. Are there any questions arising from this section, i.e. the submission document? One thing that I do want to point out is that if there are oral statements that are needed, or written statements from witnesses, then that must be put in, right? It might not be as strong as documentation, but it might be necessary depending on the nature of the dispute. Just give me 1 second. Yeah, okay. So Seelan Woodley is asking, please clarify if new evidence may be produced. I'm assuming here, Seelan, that you're talking about in the context of the referral document. Is that right? You can come on screen if you're able to.
Hi, yes, that's right.
All right, thanks, Seelan. Yeah, so yes, you definitely would be able to put in new evidence. You see, it could be that when the claim process started, and then you get into your notice of dispute, it could be that at that point in time, the documentation that you put forward to the PM or we'll get to the replication or PA might not have been good enough. So there's no problem at all, and in putting, and it's not really new evidence because you haven't really started any process, any sort of dispute resolution process in front of the PM or the PA, generally speaking. So if you've got that evidence available now, but you may not have had that evidence available at the time when the claim was put in and when the dispute was notified, then yes, definitely put it in. You must put it in, because if you don't, you may land up in the same position as before. The adjudicator might say, well, this is not, this wasn't sufficient in front of the PM or the PA, and it's not sufficient in front of me. Nicholas, thank you. Nicholas is asking, is that all right, Seelan? Does that deal with your question?
Yes, thanks, Terence.
Sure. Nicholas is asking about new evidence in replication. Nicholas, can we just pen that? We will get to the replication. Once again, it depends on whether your contract even allows for a replication. So in the context, I would argue of, for example, an NEC contract. I don't see how an NEC contract could ever allow for a replication. If you look at the time periods involved there, you've got 4 weeks. The submission document goes in 4 weeks. Goes in 4 weeks after the notice of dispute has gone in. And thereafter, there's 4 weeks to provide any other information. Now, it's understood that 4 weeks is then generally taken up by the respondent, the employer, to put in its response to the claimant's information. So once that and assuming that the employer's information goes in on the last day of that 4 weeks, there's no room for a replication there. And I don't read unless the parties specifically agree and the adjudicator is happy with that, I don't read the replication, the NEC3 as allowing for a replication at all. And so certainly in the context of the nature of your contract, that's why I said at the beginning, make very sure whether your contract actually allows for a replication, because that might inform how you deal with, how you formulate your submission document. Yeah, okay. What Nicholas is saying is that in the context of the NEC, once the claimant puts in their information within that first 4 week period, the NEC says that any other information must then go in after that, which doesn't necessarily exclude the claimant putting in putting in more information. Yes, I accept that. It might not be a bad idea at the start of the adjudication for the parties then to agree that that 4-week period is only for the respondent's response. But I accept that the NEC does not specifically allow for that. All right, Nicholas, it looks like we're gonna have a debate rather than going through on messages. It's getting a bit involved, so I'm happy to do that. Let's just go on with. Let me just finish the presentation, and then we can maybe deal with some of these questions face to face. It might be a more appropriate way of discussion. All right. The drafting of the response. Read the referral document very carefully. Don't assume that what was stated by the employer or the PM or the PA during the claim process or the dispute process is going to necessarily be formulated in exactly the same way in their response. So be very forensic about how you read it, and make sure that you go through the annexures very carefully. You know, sometimes one might miss something in a notice or correspondence when one's in the claim stage. Make sure you don't do that here. Understand exactly what the claimant's case is now. So in other words, start afresh. You obviously would also want to look at any preliminary points of opposition, what we call special defenses or eliminate defenses, such as, for example, has it been shown that there is a dispute, or that the contractual hoops have, that the contractor claimant has jumped through the contractual hoops, giving rise to a crystallized dispute for purposes of adjudication. So for that purpose, you'd want to look at your contract, and you'd ask yourself the question: does the adjudicator have jurisdiction and actual contractual power to adjudicate this? If you don't raise this issue up front, you will be regarded as having waived your right to object to jurisdiction. So now is the time to do it. Of course, one mustn't just raise these things where it just looks like it's some sort of a technical objection that hasn't much merit. It might not look good for your case at the end of the day, and you might be seen to be trying to avoid the issues. But that's not to say that you mustn't, that if there is such an objection to be raised, then raise it, and raise it properly. The other general one is time bars. Employers, I think, generally love time bars. So as an employer, you'd be looking out for that. Did the claimant do everything that they ought to have done within the time provided by the contract? And once again, you would then raise that upfront in your referral document, and you would probably raise these issues right at the beginning of the document. Bear in mind, of course, that because this is a special defense that you are raising, that the onus of proving this is on you, as in the respondent, the employer, and you will then have to make out your case for that. Of course, if you're raising preliminary objections, you must also deal with the merits of the case. Don't just hang your hat on the preliminary objections and don't deal with the merits of the case. You don't want to find that your objections are overruled, and then there's nothing opposing the merits, and the adjudicator would then probably find for the claimant. You must raise whatever arguments or facts you have at your disposal to counter the claimant's case. And you might also want to analyze the difference between the case that has been referred as set out in the referral submission document and the nature of the arguments or contentions why the claim was not upheld as put forward by the PM, as put forward to the PM at an early stage of the proceedings, and can you use this to your advantage? There may be some incongruencies or anomalies in regard to that, and you ought to make that analysis. As I've said before, you must deal with all of the allegations. Don't leave any of them out. If you don't deal with the allegation, it will be taken to be admitted. And if there is evidence that has been put up by the claimant, you should be asking yourself, well, do I have evidence to counter that? Maybe the claimant has purposefully left out a crucial notice or some correspondence that then contextualizes or puts a spin on the evidence that the claimant has put forward in its referral document. Of course, denying an allegation is better than not denying it at all. But if the allegation put forward by the claimant is substantiated by documentation, and you just deny that, well, then the denial is really not going to go anywhere. So I would suggest that if what's been put up by the claimant is documentation, and you want to deny that, or at least say, well, yes, that documentation is correct, but it needs to be contextualized by having regard to this other documentation that I'm now putting up, well then you must, you ought to do that. All right. Now, there are other issues regarding what's called the replication and rejoinder, which I don't see any of the contracts actually allowing for, and counterclaims. The only contract that expressly allows for a replication that I can see is the JBCC, although I am open to, I think maybe the CRDB. There may have been one other that allowed for a replication. No, I don't think, at least not in the ones that we're looking at today. That's not to say that a replication might not be allowed based because of the powers that the adjudicator might have, but as I've said before, rather deal with everything that you know about in your document up front, and you may just have to bite the bullet if the contract doesn't allow for a replication in a particular contract. Someone did ask about new evidence in the replication. So in the context of the JBCC allowed for, the way in which they put it is that you can't put new details which are not in your dispute, in your initial referral document, and you can't put new argument that's not contained in the details of the dispute document. However, if what is put up in the answer is something that was not in existence at the time, or you would not, or you ought not to have been reasonably aware of it at the time that you put in your referral document, you would be allowed to then deal with that particular piece of evidence or fact that is put up in the answering document, but you wouldn't be allowed to introduce new argument or new details that were in existence or you ought to have known about at the time when you put in your referral document. I understand that for many people, not being able to put in a replication because the contract doesn't allow it sits quite doesn't sit well. However, one also has to take note that these processes are robust. They're there for a reason. And if one is now getting into a situation where you're entitled to put in a replication and then an answer to that replication, by that time, the whole process becomes unwieldy, and the philosophy behind it might well fall away. It's never going to. It's not. There's no process that is completely fair, but one has to look at it at the process in general terms, and knowing that you can't put in your replication, that you can't put in a replication. Just deal with everything. Deal with everything up front. What I didn't say is, when you are dealing with allegations in the referral document, tell the adjudicator which paragraph you're dealing with. So what we do in court or what have you is we say, we give it a heading, add paragraph 2, which means we're referring to paragraph 2 of the referral document, and then you put in the content of your response under that heading. I don't want to get into counterclaims, because it's a difficult subject from a jurisdiction point of view. It may be appropriate in certain circumstances for the employer, assuming the employer is the respondent, to put in a counter referral document, but it generally does give rise to problems regarding the jurisdiction of the adjudicator, and whether the dispute that was notified is the same or similar or linked to the issue raised by the employer in the counterclaim. If there is an appropriate counterclaim to be put in, then you would put it in the same. You would use a similar formula to what you would use in the referral, but try and streamline it. You don't have to go into all the details as to the nature of the contract and the parties, etc. And if there is documentation that you wish to rely on, which is already attached to either the referral or part of your response, then refer to that documentation. Don't attach it again to the counterclaim. It just makes life unwieldy. All right. I'm just going through the comments here. Okay, and maybe we can, I think that it would be nice to actually go on camera for those who are asking the questions. So maybe I can just go through the comments in the order in which they've come up. And then the person involved can then raise the question so people can hear, and we can then just have a discussion. I don't know, Gordon had a question regarding strategy and recommendation in working with a hostile respondent. Gordon, do you want to come on? Hi.
Yeah. Good morning, Terence. Good morning, everybody. My question was really just from your experience, how do you deal with this? Because at the moment I'm working on an adjudication at NEC3 where the respondent is a government entity and he's just not interested, not interested at all in participating. Yeah, there's a number of jurisdiction challenges, then limiting the scope of the adjudication, and you know, it goes on from there.
Yeah, look, I've always said that follow the contract. I know it sounds very trite, but there may be a way that if the contractual terms, especially in relating to your option W1, has an adjudicator actually been appointed?
Yes.
Okay. So if the adjudicator has been appointed, then your next stage, you would put in your information. Now, how can the employer actually stop you from doing that? Follow the process.
No, it's not the case. The employer can stop you. It's a case of the contract required. There was no adjudicator specified, so the contractor and the client had to agree an adjudicator. There was no help in agreeing adjudicator. Eventually, they went ahead. The contractor went ahead and found an adjudicator, which then the client reluctantly agreed to. And it just sort of goes on from there. It wasn't a case of, I'm not asking you how to do it. I'm just asking you from your experience in handling this sort of thing. How do you?
Yeah, well, I would then prepare my documents, my submission documents, and I would send them to the adjudicator and start the time ticking. The contract says you put in your information within 4 weeks or whatever it is. Put in your information and use the contract terms to force the employer to respond. You see, I don't know whether, I mean, the employers say, well, we don't want to do this, we don't want to do that, but they are contractually bound to this adjudication process. Your responsibility or obligation is to now put in your referral document. Put it in. Put it before the adjudicator has been appointed. The other side have agreed, albeit reluctantly, to the appointment. Put in your referral document. Start the time ticking.
Start the process and deal with the issues as
start the process. I mean, you can't obviously stop a respondent from raising jurisdiction issues and all these other things. What is the nature of the dispute or whatever the case may be. But then, but then deal with that. I mean, if you already know that those issues are being canvassed or raised by the respondent, you may even want to deal with that upfront in your referral document. As far as you're concerned, your dispute is you've put in your notice of disputes that relates to a particular claim. That is what the adjudicator is being asked to decide. Make out your case in your referral documents. We also say in the context of court matters and litigation, if you're actually wanting an outcome, there's no point in not using the rules of court, because you've got a recalcitrant respondent. The respondent doesn't want to be a part of this. If you're not going to use the rules of court to actually get your case to court, you're never going to get to a point where you're going to get either a response from the respondent or a settlement.
No, I understand.
Sit back. I don't know whether that addresses what you're asking. I
don't think it's an easy question to answer, but I think you've sort of put things in context, so I'm okay with that. Thank you.
Okay, all right. Thanks, Gordon. All right. Bradley wants to know, should any oral statements be submitted by affidavit? I would suggest that affidavits are not necessary at the adjudication stage of the proceedings. As I've said, the strict rules of evidence don't necessarily apply to adjudications. And if there is an oral statement by someone signed as opposed to an affidavit, then I as an adjudicator wouldn't have a problem with it. what you might want to do is, you might put into your referral statement or incorporate in your referral document the actual oral statement, in the sense that, this particular person says X, Y, and Z, and in this regard, I attach a one-pager from that person who confirms that is their statement in regard to that particular aspect, so that all the facts are then contained in your referral document. But again, it depends on the nature of that statement, how long it is, etc., etc. But no, I don't believe that at this stage an affidavit is strictly necessary. All right. Uwe asks, someone suggested we are all entitled to our own opinion, but not to our own facts. Sometimes very difficult to confirm facts. Yes, it is. And the problem is in adjudication, and in the absence of a hearing, and of course, in many of these contracts, hearings, the adjudicator is entitled to call for a hearing, but because of the very short time periods involved, hearings ought to be very limited in scope. So yes, unfortunately, this is the adjudication procedure, that if there is a fact where it's one person says X and another person says Y, and there's nothing to say which of them is correct. Yes, I agree. It is difficult. It will be difficult for the person asserting the fact to then prove the fact. But that's just the nature. Of these proceedings. It might be that under those circumstances, you might then ask the adjudicator, if the matter actually hinges on that particular issue. I mean, the outcome might actually hinge on a conspectus of all of the facts put together. And with that one actually not having a huge bearing, but obviously if it's a material issue, then and then relevant to the outcome, it might be suggested to the adjudicator to hear oral submissions or oral evidence limited to that particular issue, in order to try and come to for the adjudicator to come to a finding. Are you all right with that, Uwe?
Yes, thank you very much.
Okay. As you can hear, I'm not a proponent of oral hearings. Yes, sometimes they are necessary, but when these oral hearings start to become like arbitrations, well then, what's the whole point of the adjudication procedure? It just, the whole philosophy falls away. All right. Okay. Right, Nicholas, do you want to come on screen? Nicholas has issues to share with us regarding NEC and bias of adjudicators. I'm happy to have that chat.
Yeah, we've had a couple of cases where we went through NEC the adjudication, where we follow the procedure as set out under the ECC or the term services contract even. And then we do our submissions, and the adjudicator then comes back and requests a replication from the claimant, us being the defendant. And we just want to know what is our recourse, because I mean, the time periods have lapsed, or in some cases we submit early, so the period for additional information hasn't lapsed. So the adjudicator can, in that case, ask for more information. But to ask for a full replication when the period has already expired is just for us very unusual and yeah, very problematic, as both parties have had their opportunity to state their case.
Yeah. I just want to check something, Nicholas, with option W1 in regard to the time period within which. So you've got that 4-week time period for the submission document, all right, and then the any other information that then goes in. Yeah, so that any other information that then goes in is within 4 weeks of the referral. So if the referral, so the claimant has 4 weeks to put in the referral document. If the claimant puts the referral document in week 3, then your 4 weeks starts from then. It doesn't start from, in other words, it doesn't start from the day after the contractually allowed 4 weeks. It starts from the date when the referral document goes in, which means that if you are the respondent and you then put in your response 4 weeks later, there's no float here. There's no float.
The question is really, we have had adjudicators in the past that have, with the full 8 weeks of run their course, and then the adjudicator decides he's going to allow a replication of the defendant's submission that happened in the second 4 weeks. And
I don't believe that the adjudicator is allowed to do that.
Okay, but what would we do as the defendant then? Just say to him that he doesn't have the jurisdiction to do so, or what?
Yeah. So what I would do is I would note an objection to him allowing to do so. I would set out for him the terms of the contract, and why he's not allowed to do that. And depending on the outcome of his decision, if in arriving in his decision, he takes into account the contents of the replication, I would say to you that you may well have a ground either for review of his decision, or if the claimant then seeks to enforce that decision in court, you would have a basis for opposing it on the basis that the adjudicator exceeded his or her powers. I don't know whether anyone else disagrees with me, and I think it's an interesting point. I think we ought to debate this. We could debate this. In regard to that, there was an interesting case where, and I think it's a case of Freeman NO, which was reported which was a matter that came before the Joburg High Court several years ago. And what had happened was that the adjudicator had given his decision more than 4 weeks after the contractually stipulated period. This is under NEC 3. So the submission had gone in, the response had gone in, and then under the contract, the adjudicator then has 4 weeks to put in to give their decision. The adjudicator had not given the decision within 4 weeks. It came 5 weeks or 6 weeks, a couple of weeks late, and the claimant, the employer, then said, well, that decision which went against the employer is out of time and void. The claimant disagreed with that. The claimant took the matter to court, and the claimant's argument was upheld, i.e. that the fact that the adjudicator had given his decision out of the contractually stipulated time did not nullify his decision. That decision is wrong. And in fact, subsequent case law has shown it to be wrong. The claimant, I think, was lucky in that particular case. if the adjudicator does not give his or her award within the contractually stipulated time, that is the end of the adjudication. Remember that the dissatisfaction that you can note under the NEC arises with dissatisfaction with the adjudicator's decision, or if the adjudicator did not give a decision, you put in a notice. You put in a notice of dissatisfaction. So these contractually stipulated terms must be strictly adhered to. And in my view, one, I don't read the NEC as necessarily allowing for a replication, but again, it depends on how quickly the parties are putting documentation in. So it might well be that a replication could go in if the response document goes in before the end of the second period of 4 weeks. The NEC doesn't expressly exclude that. But generally speaking, replications will be hard to support in the context of an NEC. In the context of FIDIC, you may well be able to come right. There's 84 days from the time that the submission document has to go in, and in fact, it seems to be quite flexible insofar as that is concerned, and the adjudicator might be able to get the parties to agree and stipulate a time period and what documentation may go in at various times, so as to make sure that the decision is made within that contractually prescribed 84 days. So Nicholas, yeah, that's what I would do. I would note my objection to that, and if the decision goes against you, and reliance is placed on that replication, then I would say that is a base that would be a possible basis to oppose any enforcement proceedings that the contractor seeks to bring in court, or the claimant seeks to bring in court, in order to enforce that adjudicator's decision.
Thank you very much.
Does that help you, Nicholas?
That helps me. It just, it starts becoming expensive when adjudicators continuously do this, and you have to end up in court, where the adjudication is meant to be a cheap process, and people should just stick to the procedure. Yeah,
and I agree with you, and I think that, and that's the problem. Somehow we've got to a point in South Africa that people are starting to regard adjudications as mini arbitrations. We don't have a history of adjudications like for example, the United Kingdom, where you have even statutorily regulated adjudication processes, and it really is it's a mindset issue. And as you would know, and you referred to clause 10.1 of your NEC, we always fall back on that. Like, people say, well, we'll fall back on the Constitution, but we'll fall back on the good faith clause. It really does. The parties really need to collaborate in this process. But and this is what I was saying with Gordon as well. If you stick to the contract, enforce the terms of the contract, and that could be your starting point. Obviously, if you're dealing with a recalcitrant respondent or whatever, or a claimant, you're just going to have to bite the bullet. But certainly you don't have to roll over and then pay up for something that is not contractually justified. We are hoping that through these kind of sessions that people start to understand and appreciate in the general philosophy behind adjudications, and even if in a specific circumstance there might be something which looks a bit unjust or unfair because of the way in which the adjudication is rolling out, well, so be it. It swings and roundabouts from a general point of view. All right. I'm just looking here. There was, I think Paul was asking. Sorry, Michelle. All right, Michelle, do you want to come on quickly? We've got and then just you can put your question forward so that people can hear, and then we can try and deal with it.
Oh, thanks. Basically, there are a number of adjudication rules under different contracts that give the adjudicator almost unfettered ability to summon witnesses, call for documentation, conduct inspections, and so on. When the parties present their case and their case is really not well documented, the adjudicator, in my mind, the adjudicator must give a decision. Not giving a decision is not part of the adjudicator's mandate. So the adjudicator effectively conducts his own investigations.
Sorry, are you finished?
Yeah.
Okay, so you're right. The adjudicator has the power, has an interrogation power that a judge or an arbitrator doesn't have. And the reason why the adjudicator has that is because, I think, because of the nature of adjudication, because it is a short time period, and maybe the parties actually haven't put forward complete documentation in the short time period available. I agree with you that the adjudicator's mandate is to give a decision, and the adjudicator must give a decision. What I was saying in the context of NEC was that if the adjudicator doesn't give a decision, then you just notify dissatisfaction. So adjudicators must give a decision, and they must give a decision based on what has been placed before them, as well as if they feel it necessary to ask for further documentation that might fill in the gaps. If the adjudicator does ask for that, again, bearing in mind the timeframes, and within which the adjudicator must make his or her decision, the adjudicator would be entitled to ask for that documentation to be provided within a certain period of time, and there the adjudicator would make an assessment as to how long the adjudicator would need after seeing that documentation in order to analyze it and make a decision. Having asked for that documentation, I believe that the adjudicator ought to then, once that documentation has come in, to give the parties a time period to put forward their submissions or contentions in regard to that new information or documentation. If the adjudicator doesn't do that and then arrives at a decision based on this new information, without allowing the parties a sufficient time period, again, taking into account the contractually stipulated time for giving the decision, to actually put in, to tell the adjudicator what they have to say about that documentation. And if the adjudicator then relies on that documentation in his or her decision, it may be a basis to say that the adjudicator had breached the rules of natural justice, and depending on in whose favor that adjudication decision went, the other party might have a case for contending that if and when enforcement proceedings are put forward before court. Does that kind of deal with those issues?
Yeah, it's just that frequently you deal with parties who have very different representation. One party may represent himself or herself, and the other party may have legal counsel. And normally legal counsel tends to be quite resolute in believing that the adjudicator does not really have the powers that the adjudicator has. And those decisions are invariably challenged on the basis of bias.
Yeah. Well, you know, if those decisions are going to be challenged, then those decisions are going to be challenged. I think the challenge, the challenge for adjudicators and for parties involved in adjudication is to understand the nature of adjudication and what the parameters and what the parameters are, and the powers and what the powers of the adjudicators are. For legal counsel, you see, lawyers come from a different angle. They come from matters that where judges are not supposed to come in, or are not allowed to come into the arena, or not allowed to interrogate. So when legal counsel starts getting involved in the nitty-gritties of these issues involving adjudicators, they then have this idea that what they're involved in is actually court-based litigation. Adjudicators have to know what their limits are and what their powers are. It's important, and that's why, you know, there is ongoing training for adjudicators and people who are wanting to become adjudicators, which is directed at those issues. Adjudicators ought to be strong enough to say to a party's representative, well, you know, I'm going to accept this. I note your objections, and then go ahead and do what they believe they're entitled to do. The courts are very reluctant to review adjudicators' decisions generally, and we've seen that in South Africa that are enforceable, which is correct. What adjudicators have to look out for is what we call the rules of natural justice, which is not a topic of discussion for today, but those are generally it's the right to be heard, and that the adjudicator is not biased. I'm not quite sure, you know, bias might not come into it if adjudicator says, well, I'm going to ask for this evidence and ask for comments on it. I think a party against whom the decision goes would be hard pressed to show bias because of that. The party might be able to say, well, you know, the adjudicator went beyond his powers, but to show bias would be a little bit more difficult. But the point is this: is that if we all want adjudication to be successful in South Africa, then yes, you are going to have probably going to have these test cases where a particular procedure or approach followed by adjudicator is then tested before court, provided the adjudicator has acted within his or her powers, which I think are quite broad and quite wide. Hopefully, the courts will say that the opposing party was their contentions are not correct, and will enforce that decision. So we'll just have to see how, you know, that all unravels as time goes on. But you know, that's just the way it is. You know, with these procedures, you are going to get these attacks. But I think adjudicators have to be strong and firm but correct in their views.
Thanks.
Sorry, that was Michelle. All right, we nearly finished here. I think there's, I just want to see, Paul, you wanted to just raise something? Okay, I'll deal with, okay, Elroy wants to know, before Paul does, Elroy wants to know, Nicholas' points leads to, can a party raise procedural objections outside the time window for submission, i.e. correspond with the adjudicator? My answer to that is no. Does that make sense to you, Elroy? Thank you. All right, Paul, do you want to, you can quickly come on, let's have a quick chat. And then I think if there are no other questions or what have you, we'll then be able to finish off for today.
Sure, thanks, Terence. I think the first thing I wanted to actually point out was that it looks like, well, normally what I find is adjudicators have their own agreement, which allows them to get information later and extend those time periods as he deems fit. And then in number 5 in the NEC3, because I believe that other guy was talking about the NEC3, he can instruct the party to provide further information within a time period. So it seems to me that there may be a conflict in those time periods if you try and interpret the contract between 3 and 5. But that, that aside, I only put that onto the link so to refer back to, because the point behind that is really that these timelines are contractual. We don't have a statute or anything along those lines. So it would come back to interpreting the statute, not the contract, what it says, what the adjudicator's contract says, and maybe what timelines you guys agree to. That would be my view, whether you asked for it or not. Sorry, Nicholas. Just trying to be helpful there for you.
Yeah, no. So yeah, carry on.
I think I wanted to point something out to you and get your feedback. I don't know if this is the proper forum because I believe it would turn into a proper high court debate.
Okay,
But
so before you do that, let me just quickly address what you said before in regard to the adjudicator's own agreement, which might itself contain timelines and extend powers that are not stipulated in the contract. All right. So your starting point would obviously always be the contract for the timelines. And then insofar as the contract incorporates rules, those rules. So with JBCC, you would have the contract, the JBC contract, and then the JBCC adjudication rules, which are, I believe, contractually stipulated for in the JBCC contract. So you have to read them together, right? Where you got something, for example, like the CAASA rules, right? So the CAASA rules might not be, or any other rules, they might not be contractually stipulated for, but obviously at any point in time, the parties can agree on a set of rules that would be governing the adjudication. And then you would have to read those set of rules together with the contract, and then to come to establish what the procedure is. It might be that in incorporating rules which are not meant to be read with the contract, you might then arrive at an issue of ambiguity or contradictory provisions. So one has to be very careful. It's the same with NEC when you're putting in Z clauses. Just be very careful that the Z clause isn't going to change something in the main contract and make it ambiguous. So yes, so you could, if the adjudicator says, look, this is my agreement, I want you guys to agree to that. The parties can always say, well, we're not prepared to agree to this, the procedural issues or whatever, but, we're prepared to agree to what you have to do, how much we're going to have to pay you, and whatever the case may be. But if they all agree to, sign that agreement, then that would, and it contains procedural issues, then that would extend the would extend the procedures or might supplement the procedures that are already in place in the contract or the rules. Just make sure that it doesn't contradict, because then you may well run into problems. So that I would just bear that in mind. Okay, Paul, go for it, and then maybe we'll need to have a debate in regard to the case law, the overruling case law. I'm happy to get that for you guys. Case law overruling Freeman. I'm happy to get that for you guys. I'll send it off to CAASA, and maybe they can then circulate that. All right, it's now nearly 11, Paul. So if you want to start something or not, I'm happy just to hear what the issue is, and we can maybe debate it together just now if anyone wants to stay on, or people can then merrily go their their ways today on this Friday, 1st of October.
Well, if you're keen, Terence, I'm happy to have a quick one.
Yeah, no, absolutely. Anyone. So let me just say this. Anyone. Thank you very much to everyone's participation. I think it's these kind of lectures are a little bit difficult when you can't see people and interact face to face. I hope that you've gained from what you've heard today, and if not, please don't tell anyone. Thank you, Gordon. Thank you very much for your participation. Thank you. So whoever wants to go, needs to go, please feel free to do so. Whoever wants to stay on, if we are able to stay on, Tiffany, just to hear what Paul has to say, then I'm happy to stay on for a few more minutes to hear about this issue and maybe just take it a bit further.
All right. So do you want me to go?
Go for it. All
right. So I think you're not the first person to tell me that Freeman, well, I've heard Freeman is wrong. What I've seen more diplomatically put by a couple of other advocates, and in a matter I'm dealing with right now, is where they say, they don't really say that. They just say that Group 5 is preferred. So the issue I have is, well, first of all, that we are talking about today, one of the things that you'd raised and a complaint that you raised was that when you have, you've got adjudication, well, I heard you kind of say this, is blurring the lines and becoming more like arbitration. And that is I agree, that is a problem. But when you treat an invalid adjudication award, if you read the law in South Africa, pretty much starting with Friedman, but you've got Ekurhuleni, you've got Ordell, you've got a number of cases that basically say that none of those complaints are valid because your recourse is to go to arbitration. So you've got kind of this safety net, right? Now, I'll get into the detail around Freeman in a second, but if I wanted to blur the lines and treat adjudication like arbitration, what I would do is I would ignore the ruling or the determination, if you will, in adjudication, just like you can do for a void. You take that risk, but if you think it's an invalid or a void for lack of jurisdiction or want of jurisdiction in an arbitration, you can wait for enforcement, and that's okay. That's how the law works here. But you can't, my view is you can't do that in adjudication. Otherwise, you're just treating it just like arbitration. Now, why would I say that? Because in South Africa, we don't have a law like England does. So we can rely on case law to some extent, to a large extent in the UK, but we can't do it here. So adjudication is largely really just an interpretation of the contract and those rules. And that's where Freeman starts. So what the judge in Freeman found was that, and it wasn't a couple of weeks late, it was really just a few days. But what happened on appeal was the other side. That was also another Cecil Murray Roberts type of thing, I think, or something like that. No, maybe it wasn't. Sorry, ESCOM, I think. They appealed that and said, well, it was late, so therefore it's invalid. Now, she does a pretty good job, in my view. That's my view. Of course, you probably disagree. But she interprets the NEC 3 and says, well, time isn't of the essence. She doesn't take it farther because they never raised their notice of dissatisfaction. And then she says, well, so until you do that, she shouldn't really say that, but she says time is not of the essence. Therefore, there's nothing to stop this guy from delivering it late. Okay, so he does that. He delivers it late, and she says it's still valid, and you got to abide by it. And then what? 10 years later, how many years later? Group 5 comes out, and that one says, well, they provided the notice of dissatisfaction on the last day. Well, right, the first day they could. And that, you know, if you look at it from a contractual interpretation standpoint, again, we don't have a law that says the adjudicator shall or is required to do it in 28 days. So we're not looking at a law in conjunction with the adjudication agreements. And this one says, you know, you provide your notice of dissatisfaction within 4 weeks of the time he's supposed to provide it. Then you basically move this to arbitration. And the latest case in Cecil that was a Cecil and Murray and Roberts. They actually say that. They recapture what was basically captured in group 5 in their own summary and say, well, then they, move this to arbitration when they provided their notice of dissatisfaction. So the problem is that the law still isn't entirely clear. I think it is. I think if you took those 2 cases, which you have to do, because we don't have a statute, you've got to look at those 2 cases together, and we still don't have something saying that when the adjudicator has run out of time, okay, and if you don't provide the notice, what happens? And Freeman is the law. Whether you think it's right or wrong, it is what dictates what happens at that point in time. Now, we could use a case, and I hate to say this, but I'm actually dealing with something literally that deals with this gap right now. And who knows, maybe I'm right and maybe you're right. I don't know. But we'll find out relatively soon, I believe. And that's where we're kind of filling, in South Africa, we're filling these gaps, whereas the mandate expires in the UK. And many people say that. And if you have to read a law that says shall or is required to provide an adjudication determination within 28 days or 4 weeks, that I believe that probably is the case, but it won't be the case until you have something very clearly state that in South Africa, which is why I'm asking. I mean, I don't think Group 5 overrules Freeman. If you have a different case, I'd like to hear it, or I'd like to see it. I haven't seen it yet.
Yeah, I'll send you what I've got on it. What I want to, when one, and this is all taking place within, well, certainly the Freeman case within the context of the NEC. Now,
Yes.
people have a lot of difficulty in following the NEC because it's written in sort of like in the present tense and isn't written. It doesn't have words such as shall or will or may or whatever the case may be, right? So when a clause in the NEC says the adjudicator hands down his decision within 4 weeks, it doesn't say the adjudicator shall hand down his decision within 4 weeks, and that's where right. So that's where people believe that the NEC is not prescriptive. But if that is the case, then there wouldn't be any time bars appropriate in the NEC, because it says, the compensation event is notified within whatever days, within 8 weeks or within 4 weeks from the date of becoming aware of the event, or whatever the case may be. If that's how we read the NEC, then then nothing's prescribed, and you can never, you probably can't ever have time bars if we're not going to read the NEC as actually prescribing and setting out time periods within which a person, if they want to do something, must do it by that time, right? So the way I read the NEC, and I think this is the general way that the NEC should be read, is that where, for example, it says the adjudicator acts impartially and decides the dispute as an independent adjudicator, not as an arbitrator, are we then saying that the adjudicator may act impartially but doesn't have to? Or are we saying that when the wording says the adjudicator acts impartially, that means the adjudicator must act impartially or shall act impartially? Right? Are you getting what I'm saying? So when the NEC then says that the adjudicator notifies his decision within 4 weeks, that isn't saying that the adjudicator may notify the decision within 4 weeks or may do so afterwards. It's saying this is when the decision must be notified. It's prescriptive.
So can I actually just jump in there real quick?
Sure.
If you go to W1.32, it says at the last sentence of that says, if a disputed matter is not notified and referred within the times set out in this contract, neither party may subsequently refer it to the adjudicator or the tribunal. Is that not rather what you're referring to in terms of a time bar? That's a very explicit time bar in my view. It doesn't say shall or whatever, but if you're going to talk about a time bar, it's clear that the NEC 3 knows how to draft a time bar, because that's a time bar. That's a time bar provision for sure.
I agree with you, and I agree with you, but I don't. But in my view, the fact that it's very prescriptive there, and they go further than what they may have gone in other clauses, to my mind, doesn't, as far as I'm concerned, the adjudicator's decision still has to be given within 4 weeks. And if the adjudicator doesn't do that, you see, it's a point of this. It's not about notifying dissatisfaction with the adjudicator's decision or getting the arbitration going. This is for purposes of, I think, for enforcement of an adjudicator's decision. So you could enforce that. You can start the enforcement proceedings while the arbitration has now started. In other words, there's a notice of dissatisfaction gone in, and now the arbitration is started. In the meantime, the contractor sits with an adjudicator's decision, wants the money up front now, and seeks to enforce it. The contractor has to show that the adjudicator's decision is valid, is contractually valid. As far as I'm concerned, my view is that if the adjudicator did not give his or her decision within the 4 weeks, because notice of and this is supported by the following, because notice of dissatisfaction starts from either the time that the adjudicator gave his or her decision within the 4 weeks, or from the day after that decision should have been made. So if that decision has not been made, right, by the end of those 4 weeks, the contractor who's the claimant there, and I would assume it would be the contractor who wants to then notify dissatisfaction, that time starts ticking from that 4 weeks. Now, what happens if the adjudicator 2 weeks later, in other words, 6 weeks, 2 weeks after he should have put his decision in, gives his decision? Well, does that mean that the time period for the notice of dissatisfaction, although it correctly started ticking on day one after that 4 weeks now starts again?
No, you have two ways to refer or to provide your notice of dissatisfaction or refer. If he doesn't, actually, I think a better question, which I'll follow up with, but you raise a good point there. But if he doesn't do it within the time period, then you have 4 weeks to refer the matter to the tribunal. If at any point he provides a determination, he or she provides a determination, you have 4 weeks from the date he provides that determination. However, I think the better point that you might be raising is that what if 4 weeks goes from the time that he hasn't provided his determination? You cannot then refer it because he hasn't provided the determination. You have to wait indefinitely now until he provides his determination, it would seem, based on what you're asking, I think is what, because that would be the conundrum that arises. Because if he does produce his determination, you can refer it. You still have another 4 weeks. There's two different provisions there that provide for that.
Yeah, no, sure, but the notice of dissatisfaction goes in. The time period for that starts from the date that he gives his decision, right? And one assumes, and this is what the NEC, this is the philosophy of the NEC, that when someone is to do something by a certain time, it assumes that someone will do something by a certain time, and that they're obliged to do something by a certain time if they want to rely on it. So if he gives his decision 3 weeks after the 3 weeks after the response comes in, right, that notice of dissatisfaction period starts at that point in time, right? I can't see how. And the example that you used about the 4 weeks later, or even maybe 5 weeks after that third 4 week period, I mean, doesn't that if often we, as lawyers, we say, well, let's test that by throwing out an outlandish sort of example to test the proposition. So my position is this, that on a proper reading of the contract, number one, if the adjudicator's decision, in order to be jurisdictionally valid has to come in within those 4 weeks after the further information has come in. That is the mandate. That is the limitation period in order for the adjudication decision to be adjudication decision. If it comes outside of that, it's no longer an adjudication decision under the contract. It's a nothing. It's a nullity. So that's my reading of the contract on its face. Notwithstanding that, I agree with you that that time period under W1.12 is a very specific time bar, right? I agree with you on that. But there's another. But my other reason is, as I've said, is that it just doesn't make sense if the notice of dissatisfaction then starts, the time period for that starts ticking on the day after the decision should have come in. Then it must mean that the decision, if it comes in after that, is a nullity, because then you're going to start the time period, but then stop it again. And that's not what the contract says.
No, I don't know. I don't know if I follow your logic on that one, but let me ask you this. Why, if it's a nullity after that, why not make it a nullity? Why not prescribe the time as they have with other time bars? And two, why give an option to refer the matter to the tribunal? Because then what happens? What does the contract say? If no one refers it to the tribunal, what's supposed to happen in your view under the contract? Now remember, I know what you're saying, and I've read Coulson, I've read a lot of UK cases, and I understand that when they say it expires, but one, the philosophy of the NEC is irrelevant, and two, we don't have a statute. You only have what we're talking about in front of us right now, and you are, I'm showing you there's a strict time bar in two. I'm telling you that there's two other, if you give the decision, you have 4 weeks from that decision. If they don't give a decision, it gives you the opportunity to refer the matter to the tribunal. I haven't heard you really construing these amongst themselves, but I am hearing what you're saying, and I understand how a mandate can expire, but I'm not hearing you interpret the contract with these clauses that I'm pointing out here. So why, for example, what happens if I don't refer it to the tribunal within 4 weeks? Day one, I'm unhappy. I've got a recalcitrant adjudicator, but I don't want to refer it. What's supposed to happen? Or let's say it's expired now, and you're saying it's not valid. Do I restart the process? What does the contract say? Do I get a chance to go to the tribunal? Is it dead if I don't because you have no award? What happens? It can't be a lacuna. It can't be in my view, you can't tell me that a contract is written to provide a void in dispute resolution. And that's what I'm starting to hear that. I'm not sure you have. Yeah,
that's not what I'm saying. That's not, first of all, the time bars relate to the parties, not to the adjudicator. So if you look at that W1.2, it's a time bar insofar as the parties are concerned and their entitlement to refer the dispute to the adjudicator if they haven't, if certain jurisdictional elements haven't been complied with. So that's where the time bar relates to. This isn't, insofar as an adjudicator's decision is concerned, I'm not sure that the language of time bar is appropriate or relevant. The language is rather whether that decision is contractually valid. Which is different from a time bar. So that's how I would suggest. And I agree with you that yes, we don't have statutes, but even if we had a statute, the statute itself could also be open to interpretation and it would have to go to court. So this is what, and I agree with you, this is what the courts would be grappling with. They would be seeking to interpret this contract and asking the question whether a decision made outside of this contractually, outside of that 4-week period is valid, and they'd be asking the question whether the contract actually essentially, whether the contract is to be interpreted as saying that after those 4 weeks, you can't, there is no decision to be made, your mandate has expired, right? So that I agree with you, that would be the parameters of the debate. Insofar as insofar as rendering the whole dispute resolution process a nullity, I don't agree that it does that. First of all, the notice of dissatisfaction goes in, and then if there's no decision made within those 4-week periods, and if that's and from there, provided that notice of dissatisfaction goes in within the 4 weeks, then the party notifying the dissatisfaction is entitled to go to arbitration or to the tribunal, as the NEC puts it. The contract does specifically say, and I'll just look, you should look at W1.4 brackets 3, right? And that is where you start with 2. If after the adjudicator notifies his decision to a party is dissatisfied, he may notify the other party he intends to refer it to the tribunal. He may not refer a dispute to the tribunal unless this notification is given within 4 weeks of notification of the adjudicator's decision. Okay, so that's where the adjudicator gives his decision. If the adjudicator does not notify his decision within the time provided by this contract, a party may notify the other party that he intends to refer the dispute to the tribunal. He may not refer a dispute to the tribunal unless this notification is given within 4 weeks of the date by which the adjudicator should have notified his decision. So it's just too bad if you do not then notify your decision within 4 weeks of either the decision having been given or within 4 weeks of when the decision should have been given, then the contract specifically says you can't refer that dispute to the tribunal. You finished, you're done, that's the end of it. That's what the contract says.
No, sorry, I didn't follow you with, say that again, what the contract says?
The contract says specifically, because you were asking, well, you were asking about well, I mean, how do you then, if you don't do anything after that, after the adjudicator's decision comes in or doesn't come in, then it means that you forfeit your right to go to tribunal. You do under W1, 2, and 3. If you don't put in your notice of dissatisfaction and intention to refer to the tribunal within 4 weeks, the contract says that, well, that's it. That's the end. That's the end of it. You can't refer the dispute to the tribunal anymore.
Okay, right, sure, but what I'm driving at is that under your version, if his mandate has expired, and I think that we could have a separate discussion around the difference between a time bar and an expiry of a mandate, but at the end of the day, it ultimately says, maybe how it's treated is a little bit different, but at the end of the day, it's an invalid award then on your version. If it's expired, if it's time barred, he can give his award, but it's invalid. If it's time barred, it won't matter. He can give his award, it's expired. You know what I mean? At the end of the day, it's something you can't enforce. So setting that kind of the discrepancy there aside, what I'm saying is that, all right, so now let's say he doesn't provide his award. You don't refer the matter because it's an invalid award on your version, right? All right, but now we're stuck with an invalid award and no one refers the matter to the tribunal. What is supposed to happen under the contract if you have an invalid award based on him being late and it's not referred to the tribunal? You say you lose all your rights and you're not stuck with an award. You have a 0 result. It's worse than a draw. It's like you didn't actually start, isn't it? So what would be the recourse for the claimant in this case? In that scenario, why would the contract be drafted in a way that says, well, you're kind of screwed yourself? But I'm saying, well, I'm waiting for the award. I'm the claimant. And you say, well, you were also supposed to refer the matter to the tribunal. I said, well, no, but I don't think it's invalid. And the respondent is saying, yeah, I think it's invalid. And therefore you have a 0 result because the mandate expired.
Well, on day 1, after the decision should have been handed down, right? The contract says your 4 weeks to notify dissatisfaction referred to the tribunal starts then, right? If within those 4 weeks an award comes through, right? And that award, for example, is in favor of the claimant. And the claimant then, at that point, say the award comes through week 1, 8 days after when the award should have come through.
Yeah.
Right. So on my reading of the contract, your notice of this, your 4-week period to refer to the tribunals has started on day 1. On day 8 comes the decision. Right.
Yeah.
The claimant then says, well, I've now got a decision and I'm happy with it. Right. And he doesn't then put in a notice of dissatisfaction. He hasn't put it in up to that point, up to day 8. Right. And he doesn't put in a notice of dissatisfaction. Right. It then the other side says, well, it's invalid. We're not going to pay you what the award says, what the decision says we must pay you. He then says, well, if you're not going to pay me, I'm going to go to court. They say, that's fine, you can go to court, but we're going to oppose you on this basis. They go to court, they oppose on the basis that the decision is out of time, and the court agrees with that, right? Let's just say, I'm not saying the court's right,
Sure,
the court
sure.
the court agrees with that, right? The decision is out of time. By this time, of course, the 4 weeks within which to notify dissatisfaction and refer to tribunal have gone long ago.
Right.
Right?
Right.
Well, I'm sorry, contractor.
No,
that's
hundreds.
I'm sorry, contractor, that's your problem. What I'm saying is that's what the contract says. And that it's the contractor will have to make a call. That is what the contract says. The contract says that, and we're talking about two different things. We're talking about, I think, enforcement on the one hand and going to arbitration on the other. This is what the contract says. The contract says you've got to know your 4 weeks starts on day 1 after the decision should have been handed down, right? The decision is handed down at a later stage. You've now incorrectly thought that that decision is valid, and therefore you've decided not to put in a notice of dissatisfaction, right?
Sure.
It turns out the court says it's an unenforceable decision. There is no decision.
Right.
Well, that's just too bad for you, Mr. Contractor. You are time-bound.
So I think you and I agree. What you just said, I agree with everything you just said. And I think the spanner in the works, whether I agree with the mandate expiring or not, is unfortunately the interpretation set out in Freeman. I think if our courts had relied, 10 years ago, 11 years ago, on UK findings and this sort of mandate expiring, we wouldn't be having this discussion, to be honest with you. But if you do read Freeman very closely, and unfortunately that is the law in our jurisdiction right now, and that says that time not being of the essence, not being made of the essence. And I think she comes up with that because of these clauses that you and I have just discussed around referring it to the tribunal. There is nothing that bars the guy from delivering it late. Now, you said earlier that you think it's wrong, and that's fine. I'm not gonna. That's a debate for another day. You think it's wrong. We can talk about that till the cows come home, because I don't know if we'll find a solution. But that is what the case says. That that's not wrong. And then you've got Group 5 coming after that, which says, well, and I think between you and me and the 25 people who are listening, that case is very poorly worded. They didn't synthesize, I don't know who the judge was, but he didn't synthesize the law. And unfortunately, that's what you have to do. You have to look at what Freeman says and make it make sense with yours. What he does say, and it's a little ambiguous, that he says, well, the guy's run out of time and time is of the essence, which kind of contradicts Freeman. So now we've got a problem. We actually have a problem in Gauteng under these two cases, if you read them that way. Unfortunately, as practitioners, we can't. So the only way to construe these two is to say, well, the other side in that Group 5 case did provide a notice of dissatisfaction, referring the matter to the tribunal. In support of that, Sassel versus Murray and Roberts, which is this year, a few months ago, just came out. And they summarize the case exactly as I've put it to you. Group 5 is anyway. Now, it's still a little problematic because the guy in Group 5 went further than he needed to, or the judge, male or female, and said that time is of the essence in that contract, which directly contradicts what Freeman said. So, you know, I do find it very interesting from a legal perspective. And I think I don't want to catch you off guard because I've been practicing this for weeks. This is my argument, and I'm doing it next week. You know, barring any other interpretation of the contract, those two cases are the cases we have to work with. And the very questions I've asked you of this NEC3 contract are the questions that are going to be dealt with next week. And I hope that one way or the other, it's going to be Freeman is overruled, or there'll be some synthesis of these two cases along the lines of what I'm telling you now. And I'm sorry, I'm actually kind of using you as a sounding board in preparation, which I appreciate. I very much appreciate it.
What I'm saying to you is that when I looked at Freeman, and then I looked at subsequent cases, I accept, and I'll look at them again, and we can have a debate about this or whatever another time, or via email. I'm more than happy to do that. When I then looked at those subsequent cases, I accept that they didn't expressly override Freeman in the sense that they said Freeman was wrong. I read them as citing a principle that essentially said that Freeman was wrong without specifically referring to Freeman. In other words, the approach that was adopted in those cases was an approach which was the antithesis of Freeman's approach. And I agree with you that at this point in time we have probably contradictory positions. And yes, I agree with you. The sooner that this can be sorted out, the better. What I'm saying is that the way I view it, I don't think that Freeman is right. I wasn't very diplomatic earlier. I said that Freeman is wrong. I believe that Freeman is wrong. I think Freeman is wrong, in my view, right? But be that as it may, let's see which way the courts go. You know, I think we need to know. You know, to then say, well, it's now open sesame on getting an adjudication decision. Well, if the adjudicator doesn't deliver their decision within 4 weeks, well, then when is the decision going to come through? At what point in time does the decision come through and it's enforceable? A year from now?
No, I agree with you. I agree with you with that.
You know, yeah.
Well, that's why I think that W143, I think it was, it gives you, sorry, it's 143, yeah. It does give the party a right to refer the matter to the tribunal. I guess my view is that if I look at that clause alone, if I'm the bad actor in this, let's say I'm the guy, I know I'm going to owe money. I'm going to turn around and I'm going to do exactly what you said. I'm going to say, well, it's invalid, forget you. And I'm not going to refer it to the tribunal. And I don't think that's necessarily fair because the claimant hasn't made any mistakes. It's the adjudicator who's stuffed up here, right? And then, so it does give a party an out. I just don't think it says that you can expire. You can say the mandate is expired based on what I read in that contract. And I know that it's not that clear, and I might be in the minority here, to be quite honest, but I just haven't had the discussion with somebody like yourself, and I like I said, I really appreciate your time and your thoughts on this. But the truth is that the law is unclear. That's a fact, and Freeman is the law. But I think you're right. What would need to happen is that either it's construed, and there's the case that comes out and says that, which I think I'm actually sitting on. I can't see how the judge is going to get around it, or Freeman's overruled. And this may, even after my instance, it may go to the Supreme Court of Appeal because you've got conflicting, well, possibly conflicting judgments now. And what are you going to do about it? Because you still have this case that doesn't make sense And I appreciate your comments, because there is some truth to what you're saying. And if you read the UK cases, you know, there are some that actually say, well, if the guy is late, it's expired, it's an invalid. But the problem I have with that in South Africa, just to bring it back to really the practical issues, is that, you know, we don't have a specialized court or anything along those lines to deal with it. I'm a year and 3 months out from when I actually received the bloody award or the determination. Now I'm in the High Court to enforce payment. And if I have to wait a year and 3 months on an adjudication to get payment on 2.5 million rand, are you kidding me?
Yeah,
like,
so
there's a real problem there. There's a real problem there. And that's what I've been forced to do. So, and the other problem is, again, the cases are very clear in terms of all the excuses, even in the UK. But Ekurhuleni talks about it. Cecil and Odell talk about it. So that's not an excuse. The adjudicator's award is what it is. I know it doesn't speak specifically to an invalid award other than for being late, other than Freeman. But that's it. And your recourse is arbitration. That's what the case law says in South Africa. So
in other words, the adjudicator is entitled to get it wrong, and the adjudicator may well have got it wrong, but that's not a basis to a valid basis to oppose enforcement. Right. As you say, your redress is to make sure that you go to arbitration and to get it before the arbitrator as quickly as possible. What you're raising about, and Nicholas, you can come in. I know Nicholas said he has a question relating to this discussion, but you raised an issue here, Paul, about the whole idea of adjudication is to be quick, speedy, give quick relief for let's just say the contract in most instances. But that having been said, the employer can drag their heels and force the contractor to go to court, can oppose the enforcement proceedings. And as you've found now, it's a year down the line or whatever since the adjudicator gave his decision, and you still don't have the money. In the meantime, there's probably an arbitration process that started, and it might well be that arbitration process could well end before you've even got an enforcement judgment from the High Court. And it's very interesting, you know, this point that you've raised now is actually a colleague of mine popped in yesterday, and she was raising this with me. You know, that this whole adjudication approach, we don't have a technology court in South Africa, and the rules here in South Africa and the practice in South Africa is designed to really allows for recalcitrant debtors or respondents to drag their heels. Right. So essentially, it actually you know, it puts paid to the strategy or the philosophy of adjudication by then using the court process to drag the matter out. Yeah. I was suggesting to her, and whether or not one could do this, I don't know, and I haven't actually looked at this whether it's capable, but I threw out the suggestion. When I say threw out, I didn't throw it away. I put it out there that the contractor has now instituted enforcement proceedings. Presumably it's the and we're talking here, let's just say, about a decision that's made within the 4 weeks. Okay. Sure. The employer has now notified dissatisfaction and referred the matter to the tribunal. Would you be entitled to approach the court or say to the arbitrator that you are not entitled to proceed with this arbitration, or the arbitration has to be stayed pending the outcome of the enforcement decision? Because certainly under NEC, once that adjudicator's decision is in, that decision is a contractual term, and the failure to then act on that decision, i.e., pay me the 2.5 million rand, is a breach of contract. Right. So if you, Mr. Employer, are breaching the contract, right, on what basis, if you're breaching the contract, are you entitled to nevertheless rely on the contract to take the matter to arbitration?
But don't arbitration agreements stand separate to things like that?
No, but this is under this. The contract here says you can refer it to the tribunal, right? This is where the arbitration comes in. The arbitration comes in option W1, option W1.4.
What I'm saying is that the arbitral tribunal will have jurisdiction to, well, they'll have the ability to determine their own jurisdiction in that respect and interpret the arbitration.
No, so this isn't a jurisdiction issue. This is an issue as to whether you are entitled to go whether you're entitled to go before an arbitrator, which is a term of the contract. The contract actually allows you to do that, but where you actually are in breach of that very contract as well.
No, sure. That's what I mean. I'm not sure.
So,
under arbitration
I'm not sure about I'm not sure whether my argument would hold water. All I'm saying is this: is that there is a concept in law that if a party is in breach of the contract, right, they are prevented from relying on that contract until they have rectified their breach.
Right, and that's what I'm saying in arbitration. In arbitration law, my understanding is, and I mean, I would probably need to look this up again, but my understanding is that arbitration agreements, and what I mean by that is literally a one clause line in a contract standalone to some extent. Now that's not 100%, but a party being in breach does not invalidate an arbitration agreement.
No. So it depends. So you are correct. You will find in many contracts it says that if this agreement as a whole is found not to be valid, or whatever the case, the arbitration clauses will survive termination or cancellation, or etc.
Sure, those kind of things, right?
Right, those kind of things. But that's not the case here. Here, your arbitration clause is literally a one-liner in W1.4 in either of the cases where there has been a decision or hasn't been a decision. That's where the right to refer to a tribunal or arbitration is given. And what I'm saying is that you don't need to enter into any further sort of arbitration agreement. The arbitration agreement is already in the contract. You might, when you go to arbitration, then say, well, the rules that govern this arbitration are the Association of Arbitrators or AFSA, or rules that we still have to agree on, etc., etc. But the contractual right to go to arbitration is given to the party who's notified the dissatisfaction. What I'm saying is that, and I haven't looked at this in any detail, it was just something that to try and
I think I know what you're saying.
to try and deal with this conundrum. You've now forced me to enforce it, right?
Yeah.
Through a court process. That you've forced me to do that because you are in contractual breach. You have breached the contract now, which the adjudicator's decision is now part of the contract. You are breaching the contract, and yet you want to rely on another term in the contract to your advantage while disadvantage me by breaching the contract. What I'm saying is there might be an argument there to say, I'm going to ask the court, and it could even be done on an urgent basis, depends on the facts or whatever the case may be, to stay the arbitration proceedings until such time as the enforcement proceedings have run their course.
Maybe.
Just a thought, because there is a concept that if you are in breach of a contract, until such time as you've rectified that breach, you ought not to be allowed to rely on another term of the contract.
Sure. Well, I also think that that's the other problem is you get an adjudication award or determination, and then you can just ignore it. And you already raised it. We haven't gone to arbitration because I'm trying to enforce this matter, right? And there was actually a subsequent adjudication too, actually. If I went to arbitration, I'd probably be done. I'd probably be done with arbitration, and I'm still not in front of a judge. But maybe we should let Nicholas jump in here because he was very patient and nice. He could have just spoken. I don't know. Nicholas is still on.
No, if anyone wants to come in.
No, I'm still here. Look, I tend to agree with Terence that the decision was wrong, and Group 5 should not have been given the decision. We've had another case where we've had an adjudication where the adjudicator then came back and just said he does not have jurisdiction to decide over the matter. The claimant then referred it to tribunal, and when we went to arbitration, for the defendant, of course, turned around and said that, listen, a precursor to tribunal is adjudication, and in this case, adjudication didn't happen, and that the only thing that the arbitrator can decide is that the matter must be referred back to adjudication. What would your opinion be on that?
Okay, so let me just understand this. The adjudicator made a decision saying that he did not have jurisdiction to deal with the matter. Is that correct? Was that his decision essentially?
Well, he notified it as a decision that he did not have jurisdiction to decide over the matter.
Okay, so if that's the case, if I was working in the context of NEC, I obviously can't force an adjudicator to make a decision. What I would then be doing is I would saying, okay, you say you don't have jurisdiction. I'm not sure at what point in time he's said that. What you might want to do is you might, and I don't, so did he say that right up front or after he was given the documentation, et cetera,
Only after he got given the documentation in his 4-week period, he then came back and made a decision.
Fine. So the decision was that I don't have jurisdiction. That's his decision, right? Which means he doesn't make a decision on the merits. As far as I'm concerned, as the claimant, I would then put in a notification of dissatisfaction, refer it to the tribunal, right? The tribunal is now acting as is the next step in the dispute resolution procedure. The tribunal must make a decision on not on whether the adjudicator had jurisdiction or not, but on whether the claimant must succeed in the claimant's case. I don't see how, and I've seen this before, on what basis the arbitrator is able to send if the arbitrator says, well, the adjudicator was wrong, the adjudicator does have jurisdiction, I'm referring it back to the adjudicator for decision. Under NEC, I don't see how that can possibly work.
Well, what happened in this case is just that the case now got put in front of the arbitrator, and when the defendant submitted that adjudication did not take place, and therefore the arbitrator must refer the matter back to adjudication before it can come to tribunal.
No, but in the context of the NEC, the tribunal has jurisdiction to entertain a dispute where there was never a decision from the adjudicator.
Right.
So the fact that an adjudicator says I don't have jurisdiction, you can either say that that's his decision, that he doesn't have jurisdiction, and that's his decision that you're now notifying dissatisfaction with, which is really you notifying dissatisfaction because you haven't received the relief you want to receive. Or you say, well, his decision is this thing about jurisdiction means that he hasn't made his decision, but either way, the dispute is now before the arbitrator, and the arbitrator must make a decision on the dispute.
Right. If Nicholas, if you look at W144, it really, if you read that properly, the dispute referred to the arbitration is not this exactly same dispute. They have the right to interrogate everything around that dispute. So it's not necessarily a precursor, if you will. The decision made in adjudication does not bind or should not actually influence the arbitrator. It's not that kind of an appeal. So I can't see why this guy would have referred it back to adjudication at all at this point. I'm totally in agreement with Terence.
I think it's wrong.
Thank you very much. It's the case that the argument was that adjudication hadn't taken place.
No, adjudication had taken place.
Did.
I mean, both parties had put in their information, and the adjudicator had come up with a decision.
Right. What he decided is irrelevant, actually. He came up and printed something and said to you guys something, even if it was an email. That was it. And then you come back and say, all right, we're referring it now to the tribunal, and it starts up fresh.
Yeah,
in a way.
So Nicholas has got this. I agree with you, Michelle. Paul and I are on different sides of the spectrum. As far as I'm concerned, certainly the adjudicator is employed to deliver a decision in a given time. And I agree with you. This is another way of looking at it. His contract expires either when he delivers the decision or when the time comes by when the decision was to be delivered. So one could, Paul, what Michelle is putting forward here is that it could well be that under the contractual terms of the adjudication agreement and his terms of employment, that he might be outside of that. So I suppose one could look at that. It might be that that's relevant as well in the context of a Freeman debate as well. That it wouldn't only be the contract itself, but it might also be the adjudicator's contract as well, which might be relevant or might not be. All right. I think that's about all. Is everyone happy with that?
Hey, thanks a lot, Terence. I really
should we all go have we can all go have an early lunch or a late breakfast.
Okay, great.
All right. Thank you, everyone. Thanks for your participation. Much appreciated. I hope that this is certainly this last discussion has been enlightening for me. It's always good to hear other approaches, and this is where we want to have debate, and this has been quite interesting. Thank you all very much. Tiffany, are we done?
Yes, thank you, Terence. It was very interesting, and thank you to everyone for attending.
Okay, thank you. Thanks so much, everybody.
Have a good weekend, everyone.
Thanks. Bye-bye.
Bye.